I think a common theme that seems to be going through all of the papers tonight is the child-centred approach, which is obviously something that is quite prevalent given the recent debate surrounding children's rights in light of the constitutional referendum held in November last. Tonight, Simone and I are going to address, I suppose, a particular issue that issues that we believe are extremely important in the context of reform of adoption law, but because ultimately, while there have been many changes in the area of adoption in recent years, none of those changes have really, I suppose, focused on, for example, the identity rights of children. So that's a specific issue that we're going to look at, viewing adoption through a children's rights lens. Just to give you an outline of what we're going to do, I'm just going to give you a little bit of a brief outline of the recent developments in adoption law in Ireland, just to put it in context. And then each of us are going to focus on two main areas in need of reform. I'm going to look at the issue of identity, information and tracing, and Simone is going to focus on the issue of open adoption with a view to reform. So the Adoption Act 2010 was a significant reform in terms of children's rights and adoption law in general. It specifically consolidated existing legislation in the context of adoption, the Primary Act of 1952, along with the 6 acts that amended it. It also formally established the Adoption Authority of Ireland, and it formally incorporated the Hague Convention on Inter-Country Adoption into Irish law. Then in 2012, as has been mentioned on a couple of occasions tonight, we had the constitutional referendum on children's rights. And while the result of that referendum and the insertion of the article is currently on ice, pending a court case, it is still important to identify the reforms that will be focused on in that context, and also the complementing Adoption Amendment Bill 2012, which has been drafted. I suppose Article 42A focused on a specific area of adoption law, that of the adoption of children who are born within a marital family. So ultimately, we know that that particular provision would, I suppose, have significant repercussions for those children who are in long-term care in Ireland today, who, under the current framework, I suppose, have to ultimately wait and see, live in legal limbo for a significant period of time, until it is almost a surety that their birth parents, will never come back and resume their parental duties before the child is 18 years of age. What that means in practice is that children who are, we'll say, coming up to 17, 18 years of age are coming before the courts looking at that stage, asking to be adopted, asking to be freed for adoption. Also, the referendum and the amendment tried, or I suppose aimed to ensure that married parents, for the first time under Irish law, would be in a position to voluntarily place their children for adoption. And also then there was a specific reference that provision would be made by law for children's rights to be heard and their best interest to be of paramount consideration in adoption proceedings. But I suppose within the context of all of those debates, very little focus centred on other areas that were in need of reform. And as is mentioned, specifically the areas of information, identity and tracing, as well as open adoption, as well as the adoption of children by same-sex couples, are areas that are greatly important and need to be discussed. So within the adoption process, I suppose, McCaughren made reference to this in her presentation. What is the point of adoption? What does it aim to achieve? And ultimately, it's with a view to providing the child with a good home and a good upbringing. It's a child protection mechanism, and ultimately it's a second chance for the child of having a family. In the current system of closed adoption, within which Ireland currently operates, the relationship between the birth parents and the child is terminated permanently, and ultimately the parental rights and duties are transferred to the adoptive parents. So for all intents and purposes, the child is treated as if they are born into that family. But under international legal principles, under the UN Convention on the Rights of the Child, to which Ireland is a party, every child has a right to an identity, and I suppose according to the Convention, states have a duty to ensure that the right of every child to preserve his or her identity is protected within the domestic legal framework. An inherent part of one's identity is their background, their roots and their family tree. This is all information which is absolutely integral to the upbringing of a child, both in terms of their psychological stability and development. This, I suppose, explains to a large extent why so many children seek out their parents when they become adults. The current legislation means that, I suppose, when it comes to the issues of search and reunion, the closed system of adoption still really takes precedent. There's a lack, for example, of provision for birth and adoption information within the law, and this was highlighted by the Law Society's Law Reform Committee back in 2000 as being the single great deficiency in Irish adoption law. Irish adoption law has been reformed to some extent in recent times, but as I say, this area is one that has remained untouched. As I said, the closed adoption system still very much is shrouded in secrecy. Internationally, however, the trend has been towards facilitating more open adoption practices. The closed adoption system, and I suppose the hierarchy of rights in the adoption process, has been confirmed by the Supreme Court in Ireland in various cases, such as IOT versus B, where the Supreme Court confirmed that while an adopted person does enjoy an unenumerated right to their identity and to know the identity of his or her natural mother, under Article 40.3, this must be balanced with the mother's right to privacy. And given the fact that the mother received assurances as to her anonymity at the time that she gave up the child, ultimately this swayed the judges against disclosure. This was confirmed in 2005 in the South Western Health Board and the Information Commissioner, where again the High Court upheld an objection on the part of the natural mother to the release of edited and non-identifying information to an adopted person who had been adopted 40 years previous. And again, the reasoning behind that was that the promise of confidentiality that was given to the child at the time, to the mother at the time she gave up her child, must be protected in the public interest. So the current position then is that there is no legislation governing this issue in Ireland. There is no statutory right of access to original birth certificates at 18, unlike the position in the UK. And there's no information, I suppose, from the index connecting adopted children with their birth records. And I suppose, while this can be provided for by order of the adoption authority or the High Court, they must be satisfied that this is in the best interests of children. And in terms of tracing, one of the big difficulties is that the very fact that many adoption files date back to the 1950s and onwards means there's very scant information available, and they're often devoid of very important details like medical history and medical information. But there have been some developments. For example, there was a very significant development in 2005 when the National Contact Reference Register was established, and this was one of the recommendations by the Law Society's Law Reform Committee in 2000. The purpose of the register is to facilitate contact between adopted people and their natural families. However, participation is voluntary and both parties must agree and must register. The register allows people to choose what level of contact they wish. So, for example, whether they want to communicate via telephone, email, face-to-face contact, as well as the exchange of letters and information. The Adoption Authority of Ireland maintains the register and it's not open to public scrutiny. The Adoption Authority of Ireland presented the first framework for the provision of a national adoption information and tracing service in 2007, and this was extremely useful as it set out guidance and advice and set standards for the information and tracing service nationally. Just to give you an idea of the approach that has been adopted in other jurisdictions in relation to this issue, in Scotland, adoptees have had the entitlement to access their original birth certs once they reach the age of 17. In Britain, since 1975, adopted persons are entitled to obtain their original birth certs from the age of 18. Now, there are obviously additional safeguards put in place to protect both the adopted persons and birth parents, and so counselling and resources are an integral part of the process. And then if we look at other jurisdictions like Ontario, identifying information is available to the adopted person and the natural parent, but there is an information veto, and where that's invoked, then non-identifying information is given. So in terms of reform, at the moment, at the same time as the Adoption Amendment Bill of 2012, there is also an Adoption Information and Tracing Bill, which is currently being drafted, I suppose, with a view to reforming this specific area of law. However, the Adoption Authority, it provides that the Adoption Authority will have access to records currently held by a wide range of information services and give the Authority an oversight role with regard to the maintenance of adoption records. It will also place the National Contact Preference Register on a statutory basis. It will aim to put in place proactive tracing and reunion services. But all of this, of course, is predicated on having, obviously, well-resourced counselling services for all the stakeholders involved. Based on this information, and this is only the information we have to hand at the moment, obviously it's subject to change, it would be regrettable if the bill only sought to place the existing practices on a statutory footing. Given the constitutional rights of the natural parent to privacy and obviously the various sensitivities in this area, it is understandable that there would be no unqualified right to identifying information for past adoptions. However, we would, based on the child's right to identity, we would wonder whether having a right to identifying information subject to a veto would be a possible option, and having a statutory right automatically to non-identifying information regarding the health and medical history of the person concerned. I suppose it's important to point out that that last recommendation again was something recommended by the Law Society's Law Reform Committee as far back as 2000 in the context of the non-identifying information being made available automatically as a statutory right. Article 42A, if it's inserted into the Irish Constitution, will recognise the natural and imprescriptible rights of all children in Ireland. And given that children's rights and the best interests of the child are supposed to be at the core of the adoption proceedings, surely it is their needs and their rights that should come first. The closed adoption model traditionally has protected the rights of the adults. It has protected the birth parent's right to privacy, which has been supreme and has ultimately outweighed the child's right to know where they come from. It has also protected the rights of the adoptive parents. But what about the children who are at the heart of this process? Obviously, practice at the moment, while to some extent they do try and facilitate the provision of non-identifying information, this is not contained within a legal framework. While agencies do as much as they can in terms of working within the constraints of the law, they often feel that they are doing a disservice to their clients. On the other hand, the adoptees are left feeling that they have been denied very basic, fundamental rights to which they are and to who they are and where they come from. So with that, I'd hand over to my colleague, Dr. Simone McCaughren, to talk it openly.
I think it's important that we give some consideration to the current landscape of adoption practice, because there is an argument to be made that while the process of involved in placing a child for adoption looks quite different to what it did 2 or 3 decades ago, the laws guiding the practice remain more or less the same, that we really are still operating under the 1952 legislation that's now enshrined in the Adoption Act 2010. I suppose the landscape of adoption practice has changed significantly, and it's important to remember that the change has come about due to the voices that have previously been unheard and who were previously voiceless, who were previously disempowered in the process of adoption. They've spoken out against a system that didn't necessarily work for them. They found it disempowering, they found it oppressive. And I suppose this is contributing to, I suppose, a changing adoption discourse. It's really resulted in a shift in adoption practice and a move away from that clean break theory, where all lines of communication between birth parents, adoptive parents and children were completely severed. And what has now emerged is a relatively nuanced approach to adoption practice. So Irish adoptions are now, or adoption agencies are now encouraging open adoptions, where the two families are given the opportunity to maintain some level of contact with one another. I suppose I now move on to kind of trying to define what I mean by open adoption. And the literature relating to the subject of open adoption acknowledges that there's not really one universally recognised definition of open adoption. I carried out a piece of research 2 years ago as part of my PhD, and I interviewed a number of adoptive parents who were parenting children in a variety of open adoption arrangements. And it highlighted the fact that even those who self-identify as having open adoptions have divergent views regarding what constituted open adoption. And I think those divergent views probably originated from adoption agencies who can themselves actually practice different levels of openness. So I give you this definition, which is, and there are many out there, but I like it. Siegel, she defines open adoptions as those in which the birth parents or other family members and adoptive parents share with each other some sort of information about themselves and have some sort of contact before and after the adoption takes place, perhaps by letter, by telephone, face-to-face meetings. Contact is through a third party or directly among the persons concerned. It can involve full two-way or partial disclosure of identifying information, includes one or both birth parents or other members of the birth family, and includes the potential for the child's participation in the contact. The Adoption Authority of Ireland refer to open adoptions as those where the natural parents retain some degree of contact with the child, usually 1 or 2 visits a year after the adoption order is made. However, this definition it does not take into account the changing nature of adoption arrangements, and it also, I suppose, defines it as contact that's face-to-face. In my study, I found that open adoption was really a dynamic and ongoing process. It was not a static event. It was always in a state of flux. It was always changing. And I also found that the contact arrangements, even those contact arrangements that began as the most, I suppose, minimum amount of contact, for example, just having letter contact with one another, they were sometimes the adoptions that became and grew the ones that were actually the most open. I think when we're discussing the importance of open adoption, it's important to look at the area of social networking. I suppose the .com era has meant that the area of contact and adoption, it has encountered new and unprecedented challenges. Social networking sites such as Facebook has really revolutionised the area of adoption, making it very easy to contact people and to access information. And I suppose anecdotally I hear social workers talk about, I suppose, the fear that adoptive parents have when they've initially entered into closed adoption arrangements. They have young teenagers who are curious and they describe it like their birth parents are popping up on the screens in their living room. Open adoption allows contact with the natural family to be a natural and normal part of an adoptee's life. When it's mediated through professionals, all parties can be supported through the challenges that openness presents. I suppose I'd like to bring that question, to this forum tonight, just looking at whether the law has a role to play in the area of open adoption. At present, open adoption is a voluntary agreement. It's an agreement that's drawn up by both the adoptive family and the birth family, and the process is mediated through social workers. And the reality is that agreement, it is merely a gentleman's agreement. There's absolutely no enforcement there. It has no legal standing, and birth parents and adoptive parents could renege on the agreement once the adoption order has been granted. The Adoption Authority has called for legal provisions to be put in place to ensure that where a natural parent wishes to have continued contact with his or her child after the making of an adoption order, such contacts can, in certain circumstances, be made a condition of the adoption order. And one argument is to be made that if we are to take the issue of identity seriously and truly believe that children have a right to information, then perhaps the law does have a role to play. However, making contact or access part of the adoption order, may raise constitutional concerns. In particular, Article 41 of the Constitution protects the family based on marriage and recognises the natural and imprescriptible rights of parents. So this would or could be problematic, as there may be an anticipated risk to parental rights. I think myself, having conducted the research, I would be more in favour. I would say it is more ideal for the law or for trust to have a place rather than the law. I think open adoption by its nature has to respond to the changing needs of all the stakeholders. So while the law can require, regulate and enforce post-adoption contact, it cannot influence the qualitative experiences of relationships and social interaction that adults that enable adults to cooperate and cooperate in the best interests of children. What is more ideal if families formulate an agreement that suits their unique needs. Just to finish off, I would like just to briefly look at the UK experience. I suppose traditionally the UK has avoided resorting to the courts and making contact orders. If the adoptive parents were not willing to allow contact, then the court took the view that imposing such requirements would likely to lead to problems. However, there were changes made by the 2000 Children and Adoption Act where they require the issue to be reconsidered. The legislation now states that before the making of an adoption order, the court must consider whether there should be arrangements for allowing any person contact the child. And of course, this is done in line with the child-centred approach and the best interests of the child. The question of whether contact should be permitted is for the court to decide in the UK. An interesting comment that Justice Bennett commented on in the case of REC contact. He made the following comment: the purpose of adoption is for the child to develop in a quite different family, and the purpose of contact is for identity purposes, not to develop a relationship between the natural parent and the child who is adopted. I think when we're considering the way forward, there are some important considerations that need to be taken into account when talking about open adoption. Open adoption is not a static event. It requires a huge degree of flexibility, and it is taken on as a long-term venture. It's a commitment to acknowledging the child's biological background. However, for a large part of a child's life, the success of open adoption depends largely on the commitment, the reliability and efforts of those adults who are biologically and legally related to the child. Human relationships are, by their very nature, complex. So all of this means that adopters, birth mothers and children, they need to be supported while navigating their way through the life cycle of an open adoption. Law on open adoption is one that needs careful consideration, but there's a lot to be learnt from the experiences of other jurisdictions. If Article 42A is inserted into the Constitution, then this will require that children's rights are considered central to the adoption process, and the best interests of the child are given paramount consideration. What springs to mind when I was bringing this presentation together was Kierkegaard's famous pronouncement that life is lived forward and understood backwards. We cannot escape Ireland's adoption history, but if there are lessons to be learnt, then let the future of adoption be one that respects the needs of all members of the adoption triangle, but most of all, that children's rights remain central to any decision-making process. Thank you.